A recent case in the state of Georgia shows how an open judicial disciplinary process can encourage an allegedly corrupt judge to leave the bench. In this case, a few days before the State Judicial Qualifications Commission published the findings of a disciplinary investigation of the judge resigned. The investigation had revealed that the judge had used court employees to take care of her personal business, had used a law clerk to represent her interests in a personal litigation matter, had used former convicts who were on parole to work on her political campaign, had used public money to buy her church choir robe, had tried to intervene on behalf of a male travel companion to remove child support obligations that were preventing him from obtaining his passport, had posted signs on her public courtroom door listing who would and would not be permitted to enter the courtroom, and had instructed court bailiffs to publicly inquire of people attending the court proceedings as to what business they had being there. Rather than face a public hearing on the 16 allegations and have the evidence be made public, the county judge resigned. Ironically, upon her resignation, the judge, who had spent nearly $25,000 in taxpayers' money traveling to conferences in Jamaica, Panama, and the Virgin Islands, stated that she was going to start an international judicial consulting practice. Sometimes there is in the United States bias and lack of transparency and accountability in the judicial appointment process. In the state of Missouri, judicial candidates are interviewed and selected by a panel of attorneys who are elected by their fellow attorneys. Often their deliberations are held behind closed doors. Also, most of the attorneys on the panel share the same political philosophy of most attorneys, which is sometimes less conservative than that held by most citizens of Missouri. As a result, there is no elected official the citizens can hold accountable for making poor judicial appointments. For this reason, judicial reformers in Missouri are pushing for a change that would make it the responsibility of the governor to nominate candidates for judicial vacancies, with the Missouri State Senate having the right to hold public hearings and confirm or reject the nominees. In regards to judicial training in the United States, there is only positive news. Just as Croatia's Judicial Academy trains potential and current judges, each state in the United States has an effective judicial training institute. However, there is one critical difference between the two systems. In the United States, there is no equivalent of the Council of Europe's Consultative Council of European Judges, the role of which is to facilitate the training of members of the judiciary in the states of the Council of Europe. Of particular concern is the mission of the Consultative Council of European Judges to train national judges on the knowledge, use, and enforcement of international and European law. The training of national judges by European authorities to incorporate international and European law in their decision-making, especially in the area of human rights, raises potential challenges to national sovereignty to which Croatia and other nations should pay close attention. There is something in the United States that we call judicial activism. Over the past few decades, state court judges have engaged in judicial activism by ignoring past legal precedents and making law rather than merely interpreting the law. In essence, many judges are legislating from the bench by creating new rights where none existed either in state constitutions or in the law. This has caused many citizens to wonder what underlying judicial philosophy these judges hold that prompts them to take such actions. For years, state judicial codes of conduct prevented candidates from judicial office from discussing their judicial philosophies or the approaches that they would take in deciding their cases. However, several years ago, the Supreme Court of the United States decided that the prohibition against judicial candidates from expressing their views on the law violated their free speech rights. Now, in many state elections, civil society organizations request the candidates for judicial office to complete surveys containing questions about their views on controversial areas of the law. This enables these organizations to better inform the public about these judicial candidates or applicants for judicial appointments. This brings me to another point about judicial activism. Although Croatia's reforms to the judicial appointment process will help interested citizens learn more about the background or judicial philosophies of those who apply to be judges, how many of you know anything about the judges who sit on the European Court of Human Rights? Yet, these judges have the power to overturn the decisions of your constitutional court. In fact, as recently as March 2010, in the case of Orsis and others v. Croatia, by a vote of 9-8, the judges of the Grand Chamber of the European Court of Human Rights decided that the separate education of many Roma children in several Croatian towns, for the reason of language deficiencies, was not accompanied by sufficient safeguards and resulted in prohibited discrimination against the students. This was an unsatisfactory result for the dissenting judges, who argued that when the Strasbourg-based court overrules a well-reasoned judgment rendered by a national constitutional court, it should have to present more convincing arguments to justify its decision. In this regard, it is instructive to note that in Britain, some members of the legal community have started to question the proper role of the European Court of Human Rights and to propose that Britain withdraw from the jurisdiction of the court in favor of vesting its national Supreme Court with the final authority in human rights cases. In a March 2009 speech titled "The Universality of Human Rights," Britain's second most senior judge, Lord Hoffman, explains what he perceives to be the problem with the European Court of Human Rights, quoting Lord Hoffman. In practice, the court has not taken the doctrine of the margin of appreciation for national laws and conditions nearly far enough. It has been unable to resist the temptation to aggrandize its jurisdiction and impose uniform rules on member states. It considers itself the equivalent of the Supreme Court of the United States laying down a federal law of Europe. I have no difficulty about the text of the European Convention or its adoption as part of United Kingdom law in the Human Rights Act of 1998. It was largely drafted in London, intended to reflect the common law understandings of human rights. I think it would be valuable for the Council of Europe to continue to perform the functions originally envisioned in 1950. That is, drawing attention to violations of human rights in member states and providing a forum in which they can be discussed. Lord Hoffman continues, quoting him, "The problem is the court and the right of the individual petition, which enables the court to intervene in the details and nuances of domestic laws of member states. We remain an independent nation with its own legal system, evolved over centuries of constitutional struggle and pragmatic change. I do not suggest belief that the United Kingdom's legal system is perfect, but I do argue that detailed decisions about how it could be improved should be made in London, either by our democratic institutions or by judicial bodies like the Supreme Court of the United States that are integral to our own society and respected as such. Although there are important qualitative distinctions between the status of the judicial system in Britain and that of the judicial system in Croatia, the two nations share the following shortcomings of the European Court of Human Rights. First, the judges in Strasbourg have tended to stretch the original text of the European Convention on Human Rights to situations well outside the expectation of those who drafted and ratified it. Second, decisions of the court are open to criticism on the grounds that they do not take sufficient account of the cultural and other differences between different countries. Third, since citizens from each of the 47 member countries have a direct right of appeal to the court is heavily overloaded with cases and judgments that are greatly delayed. Fourth, the competence of many judges is severely in doubt. Fifth, it is inherently difficult for any court whose judges come from 47 different countries to be democratically accountable to any of those countries. Sixth, whenever vital political matters are decided in courts of law, the power of pressure groups will almost inevitably burgeon. Individuals lack legal knowledge or the resources to fight for their legal rights. In practice, only pressure groups will be able to find the money and provide the necessary legal expertise. So in conclusion, perhaps we can agree on the following points. The European Commission is imposing very high standards on Croatia's judicial reform process, standards that are not always achieved in practice in the United States. Second, even after Croatia's accession, the European Court of Human Rights and the Consultative Council of European Judges will play a significant role in the operation and evaluation of Croatia's judicial system. I look forward to hearing from my fellow panelists and the audience members about the potential impact of these realities on Croatia's national sovereignty. Thank you.
Zahvaljujemo gospodinu Kelliju na tome što nam je pružio uvid u stanje u Americi, u pojedinim državama i također povukao paralelu sa našom situacijom u Europi. Sada prepuštam riječ gospodinu Uzelacu.